Attending our webinar on redundancy today. I've run quite a few of these now, so if you are a repeat attendee, thank you and welcome back. Good to see you. And if you're new to these sessions, the way we run these is that I'll go through the presentation. If you've got any questions, please pop them in the chat. Lily Evans is helping me here today, and she'll make note of the questions. And if we have time, we'll go through those at the end. But as most often the case, we do run out of time. So we'll compile a Q&A sheet and that will be sent out to you with the slide presentation. So you will get that after the session. Redundancy is not a favourite topic for most people, but regrettably, given increased costs of employing people and global economic pressures brought about by uncertainty on a number of fronts, like tariffs and conflicts, it is a reality facing many businesses. What we're going to cover today, or my aim is to clarify when you can use redundancy and what your legal obligations are, to identify the rights of employees, and in particular, those employees who have added protections under the law, to give you steps on how to run a redundancy process from start to finish, how to prepare and handle redundancy appeals, calculation of redundancy payments, and importantly, what you can do to support employees through this difficult time, not just for the sake of those who are directly impacted, but also to demonstrate your organisation's value and commitment to employees, those remain in the business. Let's start off by defining what redundancy is. Basically, it's a form of dismissal brought about when an employer needs to end an employment for those to reduce the workforce. So it's about making sure that there is a process for dismissing employees through redundancy when your workforce needs to be reduced. Before we go into the cans and can'ts of a redundancy process, let's take a minute to reflect on the impact of redundancy. There's a lot in HR that brings real joy. It's a privilege to be the one who tells someone you got the job, or to share the news of a well-earned bonus or a long-awaited pay rise. But there's another side to HR, the part where we have to deliver bad news. And I don't know how you feel, but I find it far easier to deliver bad news to someone whose behaviour has warranted it. The employee who, despite numerous conversations and opportunities, refuses to contribute, or someone who's bullied their colleagues, shown blatant disrespect, or behaved in a discriminatory way. But then there's the other kind of bad news, the kind that feels deeply unfair, even when it's no one's fault. Some examples of this could be a situation where the business may not be performing as it once was, or where advancements in technology might have reshaped the roles we once recruited for, or perhaps there's been a strategic decision to focus on a different product or service, and that can lead to redundancies. The impact of redundancy should never be underestimated. In my conversations with people about their careers, the moment that often leaves the greatest emotional imprint is being made redundant. Unlike other forms of dismissal, it frequently comes without warning, making it all the more unsettling. Here are just some of the human factors we need to prepare for. The emotional impact and feelings of shock, grief, anxiety, and even anger. In fact, all the emotions you would normally associate with someone experiencing loss or major loss. For many, the immediate worry is how you pay the bills. What if they've just applied for a mortgage? If they're the main earner supporting a family. The uncertainty can cause chronic stress, anxiety, and in some cases, depression or even a sense of shame. Loss of identity or purpose and stigma and embarrassment. Some people define themselves by the work that they do. And when that's taken away, they may struggle with a sense of who they are. Redundancy can also bring feelings of embarrassment or stigma, even though it's no reflection of the person's performance. I don't know if anyone here remembers the film The Full Monty maybe I'm showing my age. One of the characters in that movie loses his job but can't bring himself to tell his wife. So he keeps up the routine of getting dressed for work, packing his lunch in his briefcase, and leaving the house to go to work, only to spend the whole day in the park. It's a great movie, comedic, but with a powerful illustration of the emotional toll that redundancy can take. Then there are mental health risks. Stress can be a serious outcome of redundancy. And for someone who's already struggling with their mental health, it can make things much worse. The loss of structure, income, and purpose can trigger or worsen conditions such as anxiety or depression. A strain on personal relationships, redundancy affects the whole household. It can be incredibly difficult to tell your kids the holidays off, or to feel like you're no longer contributing equally to shared responsibilities. That strain can lead to tension and conflict at home. Workers nearing retirement age or those in specialist roles that are disappearing may find it particularly hard to bounce back too. You think of switchboard operators, travel agents, or even bank tellers, roles that have largely disappeared due to digital innovation. It happens, but training is often necessary, but it may not always be easy. Redundancy isn't just a legacy issue, it's accelerating. Many roles are under threat from automation, so telemarketers are being replaced by chatbots, receptionists by digital check-ins, cashiers by self-service kiosks, and it isn't slowing down. And lastly, but not insignificantly, work is more than just a wage for many people. It's a source, of social interaction and belonging. And losing that network can lead to feelings of isolation, especially if the person lives alone or doesn't have other strong support systems in place. In short, redundancy is more than a business decision. It's a deeply human event. And our role as HR professionals is to ensure that we handle it fairly, lawfully, and with empathy. So let's look at when redundancy can be applied. Redundancy can only be used in very specific and genuine circumstances. If you are asked to make someone redundant and you cannot hand on heart align it to one of these reasons, you can't do it. Section 139 of the Employment Rights Act 1996 sets out reasons for redundancy. Basically, the reasons all align to the business not being able to afford to keep the person or people on. And this doesn't mean that the business is going bankrupt necessarily. It may mean that there is a financial case to be made where the business could be saving money or improving profits by making operational changes. An example of this is a supermarket who puts in self-checkouts and then reduces the number of checkout cashiers, or, as I said, where a business introduces a digital check-in rather than employing a receptionist. So basically, you only use redundancy when the job no longer exists. When looking at reducing the number of employees required to carry out a particular type of work, this may be because of, as I said, an introduction of new technology or the need to preserve the business's ability to remain solvent. The economic climate, and certainly the current climate, with rising wage costs and employer national insurance increases, may lead businesses to consider workforce reductions. If redundancy is on the table, it's crucial to follow the correct legal procedures to avoid risk of unfair dismissal or discrimination claims. But redundancy isn't always the only path. This may also be an opportunity to explore alternative roles within your organisation and restructure strategically. When you can't use redundancy, basically redundancy is not, even though we might wish it sometimes, an opportunity to get rid of a problem. Think of it in terms of getting rid of the role, not the person who performs the role. That's critically important. You cannot make anyone redundant and then re-recruit for the same or a very similar position. The role has to become obsolete. Whilst there is no rule for how long you need to wait to re-recruit if your operational issues change. So example, if you've lost a key client, that meant you needed to reduce your workforce, but later you won a contract that required you to rehire, you could do this. The point is that you would need to demonstrate that you have followed and adhered to all the fair process requirements for redundancy. It's worth noting that redundant employees have 3 months in which to make a claim to the Employment Tribunal. So if you are advertising for new employees in the same or similar role within this time frame, you run the risk of an ex-employee making a claim for unfair dismissal. And just on that time frame of 3 months to make a claim may very well be extended to 6 months under the changes being proposed in the new Employment Rights Bill. In an unfair redundancy dismissal case, the tribunal will look at whether there is a genuine redundancy situation and the business reasons that have led to the situation, and the burden of proving this lies with the employer. Before you consider if redundancy is your only option, it is advisable to work through the following considerations. So I would recommend don't continue to employ people unless there is a very specific skill or requirement that can't be possibly performed by the people at risk of redundancy. Can you take a creative approach to protect jobs? Maybe a change to operational hours. Look at the whole of the operation. Can jobs be redefined or merged, or can you provide cross-skill training that would negate the need to make redundancies? Would a temporary closure or layoff ward off the need? This is a very typical scenario in manufacturing industries, for example. Can at-risk workers be reassigned to other departments? Or could you consider offering voluntary redundancies to negate the need to make anyone redundant? Just a quick poll before we move on, please, to look at the redundancy process, if you don't mind. It's anonymous, so don't be embarrassed. Please answer which of the following statements best applies to you. So I think it'll come up on your screens now. A, I have an up-to-date redundancy policy that is fit for purpose. B, I'm not sure if we have a redundancy policy. C, we have one, but it hasn't been looked at for a long time and it might not be up to date. Or D, no, we don't have one. I'll give you a moment or two to answer that. A number of you are saying that you do have an up-to-date policy. That's good. Some of you are not too sure. Some of you know that you haven't looked at it for a while, and there's quite a number of you who don't have a policy at all. So thank you for answering that. That gives me an idea of what I'm dealing with here. And we'll certainly talk to that as we go through. Perfect. Thank you very much. The reason I asked that question in the poll is because the very first step in any situation where you need to use redundancy is to look at your redundancy policy. And a redundancy policy should identify what the organisation will do before considering redundancy, what your process is for both individual and collective redundancy consultations, how you will apply fair and objective criteria for selection, so what factors you will take into consideration, so example, skills, qualifications, experience, attendance, disciplinary records, and performance, where of course that can be demonstrated in measurable standards. It should also state that selection will not be based on any discriminatory factors such as age, gender, race, disability, or any other protected characteristic. So as an example, if you were looking at attendance being a criteria, but an employee's poor attendance was due to a disability, you would have to disregard that. Special consideration categories and the rights of these employees, and we'll go through that in a moment. What the redundancy payments will be. Is it just statutory, or do you offer enhanced redundancy payments? what the notice period is, and your appeals process. If you are a unionised site, and I know there's a couple of people who are here on this webinar today who are, you will need to look at your collective agreement and obviously comply with those requirements. And lastly, you need to check if there have been any redundancies made in the preceding 90 days to make sure that you determine if individual or collective consultations apply. Currently, if you are making 20 or more employees redundant at one establishment within a 90-day period, you will need to follow the rules for collective consultation under the Trade Union and Labour Relations Consolidation Act 1992. So that's important. So let's look at individual consultations. Employers must give as much warning as possible for impending redundancies to enable employees to be prepared and take steps to adjust to their change of circumstance. This obligation to warn is separate to the duty to consult. The Court of Appeal has held that meaningful consultation should begin at the formative stage when employees still have an opportunity to influence the outcome. So earlier is better. When consulting with individuals, you need to provide them and or their representative in writing the information as stated on the slide. So the reasons for considering redundancy, how this could impact on their role, any alternatives that you're considering, and anything that they would like you to consider, an explanation of the process and the timings, agreement on the selection criteria if this is necessary. And that will depend on the number of roles being considered for redundancy and the number of people who may be impacted. Of course, selection criteria is not relevant if the whole team is being made redundant and there aren't any positions to apply for. And remember, having agreement and then applying the agreed criteria will make it much easier to manage if there's any appeal. The other things to include are the proposed method of calculating redundancy payments over and above statutory redundancy. And lastly, what support or assistance impacted employees can expect from the business. Collective consultations apply when you have 20 or more employees being made redundant in that 90-day period in one establishment. And remember, this is the sum total of redundancies, not the number per incidence of redundancy or by job role. Whilst there is no single definition of this in legislation, case law suggests that for the purposes of redundancy, an establishment refers to the local unit or entity to which the redundant employees are assigned to carry out their duties. So when assessing whether a unit is an establishment, a tribunal will consider the physical and organisational separation. So is it a branch, a store, or a standalone office? The local management structure, so the local decision-making authority and supervision. Stability and permanence, is it a long-standing unit or is it just temporary? The assignment of employees, so are the employees based and managed there? With a collective consultation, you have a duty to consult with the appropriate representatives. If there is no recognised trade union, you will need to arrange for the election of employee representatives to carry out the consultation. A good and fair way to determine who the representatives should be is to call for nominations and run a ballot for employees to vote for who they want. Section 188 of the Trade Union and Labour Relations Consolidation Act 1992, that's a bit of a mouthful, outlines the legal requirements for collective consultation, including timeframes for consultation and the rules which govern the election of employee representatives. So it's a good piece of legislation to look at. Consultation periods are outlined as at least 30 days before the first dismissal, where you have 20 to 99 employees being dismissed, and at least 45 days before the first dismissal for 100 or more employees. The number of representatives needed to conduct a collective consultation is not specified in law, but you must ensure that the representation is sufficient and takes into account the types of employees who are impacted. And any circumstances like geographic location or varying shift patterns, etc. So a quick example, if you were looking to close one of your manufacturing plants, which employed machinists, managers, administration clerks, and perhaps some cleaners, the representation should include at least one person from each of those employment roles, so that you get a fair representation of everybody who's impacted. Just like with individual consultations, you need to ensure that you provide the reasons for redundancy, the potential impact, the number and categories of employees who could be impacted, and the proposed selection criteria if a selection process will be needed. Also, collective consultation doesn't mean that there won't be individual consultations. So individual consultations should still be held following a collective process. However, it's likely that that individual process will be streamlined, as many of the issues would have been raised in the collective consultation process. With collective redundancies, there is also a duty to inform the Secretary of State for Business Innovation and Skills about the proposed redundancies. You need to do this by submitting the form HR1 to the Insolvency Service. This form needs to be submitted at least 30 to 45 days prior to the end of the first dismissal. And obviously this is based on whether the consultation period is either 30 or 45 days. And you can find that form on the gov.uk website. So a quick recap on the consultation process. Consult early, provide as much information as you possibly can, give adequate time for employee responses, and demonstrate that you've given fair and proper consideration to any responses that you get as a result of the consultation process. So that's important, and that's something that sometimes gets overlooked. If people are giving you feedback, make sure that you don't just look at them, but that you look at them and you can, if you needed to, demonstrate that you have considered them fairly, you've given them, gone through a due process of that before you embark on the consultation process. Moving on to employee rights. As I mentioned before, there are some special consideration categories when it comes to redundancy. Pregnant employees and some new parents have special rights for what is called a set redundancy protection period. And as stated on the slide, employers must offer employees in these categories a suitable alternative vacancy if one exists. So, for example, where there are 3 redundancies and only one possible alternative role, this means that anyone in a special consideration category would basically jump the queue and be offered the role in the first instance. This applies regardless of whether the other employees may be deemed to be more suitable. So anyone covered by a protected redundancy protection must be given priority. If an employer does not follow this, it is likely that the protected employee could claim automatic unfair dismissal. And if the person is pregnant or on maternity leave, it could also lead to a claim of pregnancy and maternity discrimination. The redundancy protected period refers to the time that employees on maternity or other nominated family leave receive enhanced protection against redundancy. So employees who are protected are those on maternity leave, on adoption leave, or in some cases on shared parental leave, and I'll give you more detail on that in a moment, or who are pregnant or recently returned from family leave. Let's have a closer look at each of these protected characteristics or categories. Protection starts from the date the employee notifies the employer of a pregnancy. So note, this doesn't have to be backed up by medical evidence to be effective. There has been some concern raised that someone who gets wind of potential redundancies could state they're pregnant to be assured of an alternative role, and then at some point in the future, after the appointment has been finalised, claim a miscarriage. Now, there's no correct response to that. It is possible, I guess, but it seems rather a drastic measure for someone to take, but who knows? In the case of maternity leave, the protected period lasts up to 18 months from the birth date or the expected week of childbirth. Where there is a situation of miscarriage within the first 24 weeks of pregnancy, so within the first 6 months, the protected period ends 2 weeks from the date of the end of the pregnancy. And where there is a stillbirth, that's anything after the 24-week period, so after 6 months, the redundancy protection ends 18 months from the date of the stillbirth. Anyone who is on adoption leave also falls under the redundancy protected period, and this will apply from the day that the employee's adoption leave commences, or where it's an overseas adoption, on the day the baby arrives in the UK. This period is the same for birth or maternity and lasts for 18 months. For shared parental leave, the redundancy protected period starts on the day the shared parental leave begins. However, if the employee is taking less than 6 weeks shared parental leave, the protected redundancy period ends on the last day of the block of leave taken. So it is only in place for the actual time they are on leave for. That's where they take it for less than 6 weeks. If, however, they take 6 weeks or more of continuous leave, then the protected redundancy period will end at 18 months after the date of the birth of the child. You may find, and maybe this is me being a bit cynical, that in some circumstances, this may impact on how much shared parental leave is applied for, particularly where there is a perceived risk of redundancy. As noted on the slide, if the employee takes discontinuous leave, the protected redundancy period will finish at the end of each period of shared leave. I hope that's all clear. Moving on to neonatal leave. An employee who takes 6 or more consecutive weeks of neonatal leave will also have protections from redundancy. And as you can see from the slide, this is for 18 months from either the date of birth, and that's for either birth parents or the intended parents in a surrogacy situation, or from the day a child is placed in adoption, or when a child who is being adopted from overseas arrives in the UK. So what happens when you have more than one person who is eligible for protected redundancy and only one alternative role? How do you choose who gets the role? Unfortunately, eeny, meeny, miny, mo doesn't cut it. So in this situation, you would apply the selection criteria that you would normally use to identify who should get the role if there wasn't a role, if there wasn't a situation of protected redundancy. So you would use the same kind of selection process. We're looking at managing a fair selection and consultation process. And the key to doing this properly is not just about being fair, but to do everything in a way that you can prove and demonstrate that you have been fair, objective, and consistent in any decisions that are made. The easiest way to do this is to be really transparent and upfront by giving early advice, as I've said, and as much information as possible. Sometimes this is tricky. I mean, a lot of companies will not want to share information that could potentially hurt them if it got out to competitors or clients or other sections of the business. The other key must do is to develop a plan. You run the process like a project, and I'll be giving you some ideas on what to include in a plan in the next slide. Ensure that you have objective criteria and a robust and auditable selection process. I can't stress that enough. We spoke at length about consultations earlier, and you will need to demonstrate that you've done this properly. That is, that you've used the right consultation process and within the specified timeframes. And lastly, and I can't stress this enough, please document everything. Prepare as if you were going to have to front up to a tribunal. Keep records of all agreements, all selection criteria, and any process that you have undertaken to establish it. Have the employees scored by appropriate people, and preferably more than one person, to demonstrate objectivity and fairness. The best way to start the whole redundancy process is with a well-defined plan. Preparation is the key. So gather evidence and be clear on your business case for making the roles redundant. Please, at this stage, do not put names to these roles. Remember, it's about the role, not the person in it. Where you can, map alternative roles and document what these are and what rationale exists for why they may or may not be suitable. So you could start by listing the potentially redundant roles and identify the key skills, knowledge, experience that employees would need to undertake those, and see whether those skill sets could be applied to other roles in the business. What would it take to bring or prepare those people to be prepared to undertake another role, perhaps training, but have a look at that comparison. And once you've done that, then it's time to start identifying who the impacted employees are, and note anyone who may have a protected redundancy period, the categories that we just spoke about. Build a timeline of when you will communicate, when you'll run consultations, and undertake the assessment process, the selection process. Explore what redundancy payments and notice periods apply based on your policy. And lastly, consider the appeals process. This is a sample timeline for once you have your plan together. So week 1, the at-risk meeting should explain the reasons why redundancy is being considered. This is where you confirm the roles that are at risk, provide the timeline for consultations and decisions, provide information on the process, and ensure that you confirm the employee's rights to representation. It is recommended that you provide a minimum of 2 weeks for individual consultations. And of course, as part of week 1, you'll send out invitations and include the information you provided at this meeting in writing as well. Weeks 3 to 4, this is when you run the consultations. During the consultations, you will discuss the employees' views and alternatives to redundancy and answer any questions that they have. Invite feedback on the process and the selection criteria if appropriate, and keep a record, as I said, of all discussions. Week 5 is when you go through the selection process using your selection criteria and introducing any feedback that you might have got through that consultation process. Keep, again, an accurate record of any scoring or assessment that you are using and be able to justify that. Invite affected employees to a final consultation meeting where you'll present the outcome of the consultation, confirm the redundancy decision if there is no alternative, and provide written details of the notice period, redundancy pay, the appeals process, and any support that you can provide. Week 6 to 9 is where the notice period is worked or paid in lieu. So you confirm redundancy and final pay, including the statutory pay, notice pay, accrued holiday, or any other contractual entitlements. And we'll talk through this in a bit more detail in the next slide. And week 10, if any appeals are made, these will need to be heard and responded to in a timely manner. As we discussed earlier, the selection criteria should be discussed as part of the consultation process an employee should be completely clear and, where possible, in agreement with the process, the selection criteria, and how the scoring will be done. I think I said to you before, if you can get agreement, then it just makes it so much easier if you find yourself in an appeals process. Determine who will be best placed to do the scoring based on what criteria you're using. So if you're using a manager, make sure it's a manager who has an understanding of the employee's performance in that role. So just as an example, if the person who's managed the team has recently left and you've got a replacement manager who's only had a month or so service, will that person be able to adequately make comment on the individual's performance? Equally, if you've got two teams that are impacted and two managers assessing their teams, you need to make sure that there is a moderation process so that the ratings between the two team managers is deemed to be fair and reasonable. Where possible, use objective and documented evidence as part of the selection process. So things like performance review ratings, stats on sales if they're in sales, NPS scores if you collate those, attendance records, and any current disciplinary issues that you have documented. Let me share a case I came across recently that highlights the importance of timing and transparency in the redundancy process. This was a Supreme Court case involving an employee who challenged the fairness of the redundancy. The issue centred on when the selection scoring took place. In this case, the manager, while considering potential redundancies, created a scoring matrix and assessed the team members on the 10th of June. One employee received the lowest score. However, they weren't told they were at risk of redundancy until the 30th of June, and the consultation process only began at that point. The employee was formally made redundant on the 14th of July, but wasn't informed that the scoring had taken place before they were notified or consulted. In fact, they only saw their scores after the redundancy had been finalised. The employee in question appealed the dismissal internally and was unsuccessful, and then went on to lodge a claim for unfair dismissal. It was during the tribunal proceedings that the early scoring came to light. The Employment Tribunal initially dismissed the claim, deciding the process was fair overall, but the Employment Appeal Tribunal disagreed, finding that the lack of proper consultation, especially scoring done before any dialogue took place, made the dismissal unfair. The case then went to the Court of Appeal, which ultimately sided with the employer, ruling that the process had not breached employment law and that the dismissal was not unfair. So what's the takeaway? Even though the employer succeeded in the end, the case highlights just how risky it is to get the sequencing wrong. So even if your intentions are sound and the outcome might not change, scoring employees before consulting them can easily be seen as evidence that the decision was already made, it was a fait accompli, and undermine the fairness of the process. So the lesson here is simple. Follow the process by the book. Avoid shortcuts that could give the impression of a predetermined outcome, because once a claim is raised, the time, the cost, and the stress involved in defending it, even successfully, can be significant. We often get asked by employers about whether they can use the last in, first out approach. And the answer is yes, but only to a degree. ACAS guidance recommends that it is not used as the sole criterion, so please use with caution. Having said that, it can be a really helpful tool when using it as a tiebreaker. So as I say here on the slide, when everything else is equal and you need to find a way to separate individuals potentially who both have protected redundancy periods in the decision-making process, you could use it then. A further word of caution though, if you are going to use this, you have to use it consistently. So you can't apply it in one situation when it suits you and not another. There is a formula for calculating statutory redundancy pay. And in fact, if you go onto the government website, www.gov.uk, you can input criteria and have it calculate the number of weeks of pay that apply to individual employees. It's a very handy little tool. Statutory redundancy pay is only payable for anyone who has worked with their current employer for at least 2 full years. Under 2 full years doesn't apply. The payment is based on age and the average weekly earnings of the employee over the 12-week period prior to the employee receiving their redundancy notice. For the purposes of calculating average pay, you will need to include bonuses, commissions, and overtime. Statutory redundancy pay is capped at a total of £719 currently. That changes pretty much annually. I think it was £700 before. And the maximum amount of statutory redundancy pay is also being capped, and that's at £21,570. So they can't get more than that. Statutory redundancy is capped at 20 years of service. So if anyone has worked for you for 26 years, you would only calculate their redundancy on the last 20 years. So as you can see from the slide, you need to apply a sliding scale of payment to employees relating to their age. So for any full year they've been employed by you at the age of 41 or over, they'll receive 1.5 weeks of their average pay from the last 12 weeks. And if they've worked with you for a full 3 years and they're now 48, they will be getting 3 times 1.5 weeks. So that means a total of 4.5 weeks of their average pay calculated on the last 12 weeks of employment. I hope that makes sense. I'm just going to touch on now how notice periods are applied, particularly in relation to payment of redundancy. So where you pay in lieu of notice or pile-on, that is where you don't require the employee to attend work. You need to ensure that you calculate the redundancy payment up to the last day of what their statutory notice would have been if they had to work, not the day they physically stopped working for you. Statutory notice is worked out at 1 week of notice for every year of service that they've worked between 2 and 12 years. And if they've worked for you for 12 or more years, then it's 12 weeks in total. If an employee has contractual notice longer than statutory notice and they are paid pile-on, then it is worked out by calculating how many weeks of statutory notice they would have been entitled to. And then that statutory notice would be added to the actual leaving date. This will then provide the relevant date to work out how many years of service and how many weeks of redundancy pay they're entitled to. Redundancy pay should be made when the employment ends or on the employer's final payday. So if they're usually paid on the 28th day of every month, but their last day is on the 20th, they'd be paid on the 28th as usual. Redundancy pay should not come as a surprise. This should have been communicated to them in writing ahead of time, and they should be aware of when, how much, and how their pay is being calculated prior to the payment being made. Now let's move on to appeals. As part of the redundancy process, you must allow a right of appeal to the redundancy decision. Again, this should form part of your redundancy policy or be part of your contract of employment if you don't have a policy, and be included in your redundancy plan. The policy should contain how long the employee has to lodge an appeal and give them a clear indication of what they need to provide in writing to have the appeal heard. So typically an appeal will be around the decision not being fair, the redundancy process not mirroring what is in the policy, or it might be to challenge why the need for redundancy is there in the first place. Once an appeal is submitted, it's important to acknowledge it promptly. Let the employee know in writing that their appeal has been received and outline the next steps, including who will be handling the appeal and the expected time frame for reaching a decision. The appeal must be heard by someone impartial, so ideally a manager who was not involved in the original selection or scoring process. If the same people are involved, it creates a clear conflict of interest and undermines the fairness of the process. During the appeal meeting, give the employee plenty of time to explain their concerns. They should be encouraged to share their reasons for appealing and any evidence they believe that supports their case. And don't forget, they have the right to be accompanied in this meeting. In most cases, appeals focus on how the scoring was applied, usually because the employee doesn't agree with the score that they were given or feels it wasn't a fair reflection of their performance. That's fairly typical. And that's why it's so important to be transparent and consistent in how you apply scoring criteria. And wherever possible, as I said, use measurable data or metrics rather than relying on subjective opinion. Once the appeal has been heard, you will need to make a clear decision and communicate that. And there are one of two possible outcomes. Either the original decision is upheld, meaning the appeal is not successful, or the decision is overturned based on the evidence presented. Clearly, redundancy is a very involved process and there are lots of moving parts. And as I've stressed throughout this webinar, you must start the process as if you were going to be required to provide evidence in a tribunal. We are currently putting together a redundancy pack that will be launched in the week of our annual conference in early July. And if you're not a Cintra HR client, you will be able to purchase a pack that contains a redundancy policy, a manager's how-to guide, and templates of all the documents that I've listed on the slide, and maybe some that I haven't yet put down. Those packs can be bought as a standalone document or information pack, or with up to 1 hour of consultation with an HR advisor if that's needed. And my advice is don't battle this alone if you're new to it. So sorry for the bit of shameless self-promotion there. If you would like more information on these packs, please put your name in the chat and we'll send you information on these as soon as they're launched. To wrap up, let's turn our attention to the support that you can offer, both to those facing redundancy and to the wider workforce who may feel the ripple effects of these changes. I started the webinar by talking about the impact of redundancy and the importance of recognising the profound impact that this can have on people's lives. Before you begin any redundancy process, take a moment to consider what support you already have in place and what additional help you can offer. And that might include access to an employee assistance program. It might be support from mental health first aiders, if available, or bringing in an external wellbeing or counselling service, perhaps. You could also consider offering outplacement support, and this often includes things like help with writing CVs, interview coaching, advice on retraining, or identifying transferable skills for other roles. Another practical gesture is offering written or verbal references to those being made redundant, even if that's not something that you would normally provide. And finally, make sure that you've explored all your redeployment options within your organisation. Speak to other departments, check upcoming vacancies, and genuinely try to find alternative roles. You might have a sister company, there might even be some suppliers or clients that you can talk to if you think that's appropriate. And this is not just good practice, it's part of your legal obligation to minimise redundancies wherever possible. And of course, it's not just those directly affected by redundancy who may struggle. The very mention of the word redundancy can send shockwaves through the wider workforce. It's completely natural for people to start questioning their own job security, wondering whether this is just the beginning and worrying about what might come next. So how do you manage that reaction and rebuild trust? The most effective approach is to be open and transparent. Make sure your senior leadership team is aligned and committed to sharing clear, honest messages about why the changes are happening, what they mean, and what the future holds. The big question is how you can rebuild morale after redundancies. So some ideas are to hold team meetings, to acknowledge the changes and explain the rationale behind the decisions. Honesty goes a long way in maintaining trust. Have your leadership team share their vision for the future. Talk about what the business is focusing on and how you plan to move forward. And invite questions, even the tough ones, and respond with as much honesty and clarity as you can. Employees will value this level of openness, and it helps them feel involved, not just informed. It's also important to show recognition and appreciation for those who remain. This could be as simple as a thank you message from leadership, or more structured initiatives like peer or manager-led recognition schemes. And celebrate the small wins to help reinforce a sense of progress and purpose. You can also encourage people to have a voice in shaping the path ahead, so ask for their input. What new ways of working can they suggest? Do they have any ideas for solving workload challenges? Or perhaps they can be part of redesigning processes. Even small suggestions can have a big impact on morale when people feel heard. And finally, think about what you can do for team building activities. So whether that's formal or informal, these can help bring people together, build better working relationships, and remind everyone that they're part of something meaningful. One last point to make is it's really important to support your managers through this process, to equip them with the right tools and messaging to have those difficult conversations, to respond to concerns, and to reinforce a positive and future-focused culture. Before we sign off, I'd really like to extend an invitation to you all to attend our upcoming conference in Newcastle on the 8th and 9th of July. There's no cost to do this, and we have a really good lineup of sessions to choose from. You'll see a little pop-up box, I think, come up on the screen. I'm running a few HR-related sessions, but don't let that put you off. There'll be a lot of other wonderful sessions for you to engage in. It'll be really wonderful to see you all in person. We'll leave the webinar open for about 5 minutes or so. So that way, if you've not had a chance to post a question and you have one that you'd like to ask, please put that in the chat. And we'll promise to send out a list of all the question and answers and get back to you with the slide deck. So all that remains for me to say is that I hope you got some value out of our webinar today. Thank you so much for joining us. So basically it's goodbye from me, goodbye from Lily, and see you next time. Thank you, everyone. Bye-bye.